I te tuatahi, mihi tēnei ki te atua, nāna nei hanganga mea katoa. Tuarua, ki ngā mate, e whiturangi hia, haere atu rā, ko paki nikora, e takoto ana ki tūhoi, te o era, huri noa kia tātou, te hunga ora, ki a koe matua, e whakatau ana i a tātou i tēnei pō. Ki te mana whenua o tēnei rohe, o tauranga moana, ko pūtaua ki tēnei, e mihi ki a koutou, no mauao, Ngāti rangi nui, Ngāti Pukenga, tēnā koutou. Ki tōku whānau, e tai mai nei, ahakoa kei roto i te hōhi pira tōku pāpa i te ata nei, kia ora, pāpa, o tira ki a tātou katoa. He tino hōnore ki te tai mai i tēnei pō, ki te kōrero, ki te toha whakaaro me ki a koutou katoa. Kia ora, everybody. Thank you all for making time on a random Wednesday night, still in winter, with not great weather outside, for coming to the lecture tonight. I apologise in advance if I have a wee bit of a cough. I caught COVID about 10 days ago. I'm not contagious, but I'm still suffering sort of the remnants of that. So aroha mai if I've got to take a few pauses to sort of clear the chest. It's a great honour and privilege to be invited here tonight to deliver this newly branded Thompson Wake lecture. I was asked when it was still Mackenzie Alvin Law. At the risk of oversharing way too early, I've got quite a long history, as Fiona pointed out, with the Mackenzie Alvin whānau / the Mackenzie Alvin legal dynasty. As she mentioned, I first came across the whānau in my first year of law school down in Dunedin, where I attended Knox College with both Tom Alvin, who was also a partner at Tompkins Wake, and also Harriet Alvin, who I lived with for a number of years. And she also works at Tompkins Wake and is sort of the boss of the whānau. I lived with her for about 4 years. And there's something pretty special about the bonding experience of Otago University and living in grungy flats for a period of time. To Fiona and Graham, I'd like to take this opportunity to thank you publicly for the emergency funds that you would regularly send to Harriet that paid a disproportionate amount of our power bill at times. Given my primary connection to the whānau is through those independence gaining couch burning Otago University years, I suspect the invitation to speak this evening is not because of that, but in spite of it. I thank you for the invitation to share something or share my thoughts about a topic that I care about. I'd also like to thank Waikato University and the Te Piranga Law Faculty. As you alluded to, over the years, Waikato University have been thought leaders and very progressive in the Māori legal issues space. As you mentioned, your whole ethos is about a bijural education. And I think what we're seeing now is many of the law schools really just trying to catch up to where you guys have been for a long period of time. So ngā mihi nui kia koutou. In terms of where I wanted to start this lecture, I wanted to take it back, like way, way back, to when, hang on, let me see if I can get this going, to when my tupuna or ancestors first arrived on the beautiful shores of Aotearoa approximately 800 to 1,000 years ago. They came on the Mātātua waka, which was one of the earliest voyaging canoes that undertook the great navigational journey across the seas from our homeland of Hawaii to Aotearoa, New Zealand. The captain of that waka was the rangatira or chief Toroa. But we're not going to focus on the man for the purposes of my story. Instead, I wanted to focus on his renowned sister, Muriwai, who was also on the Mātātua waka. She was a wahine of significant mana and standing in her own right. And accompanying her on her journey, or on that journey, was her 2 twin sons. Now, there's a reason that Aotearoa was, of course, one of the last places on earth to be settled, right? We live at the bottom of the world, geographically isolated, and the seas around us are known for being perilous and treacherous. Unfortunately, on the journey from Hawaii to Aotearoa, both of Muriwai's twin sons tragically fell to their peril and drowned in the Pacific Ocean. As you can imagine, Muriwai was devastated. As a response to the drowning, Muriwai placed a rāhui over a vast tract of the ocean. It spanned approximately 300 kilometres. Going from the point up there, Ngā Kuria Whare, which is just outside of Tauranga, Bowen Town, I think, and it spanned all the way to Tihiro in the east coast. So for those who have been along there, Cape Runaway, Whangaparawa. So that rāhui was one of the first and one of the largest rāhui that was known. That rāhui is significant not only because of the expansive area that it covered, which was large, but also because it's said to have lasted for generations. The effect of placing that rāhui was to make that area tapu, or sacred, and an area from which you shouldn't traverse or gather food, right? It became cordoned off, a no-go area. The significance of closing the ocean cupboards as one of our primary sources of food for a navigational coastal living people should of course not be understated. It was a big deal. And it's a statement about Muriwai and her mana, or standing, as well as a statement of her grief for her tamariki. That rāhui is still spoken about by those that live, many of the iwi that live along the coast today. Now I want to fast forward you 800 to 1,000 years to the 9th of December 2019. A day whose events are forever etched into our history, where another ocean tragedy struck in our collective backyard. Te pahutanga o Whakaari, the 2019 eruption of Whakaari. There were 47 people on the island when Whakaari erupted. Sadly, 22 died, either in the explosion itself or later from injuries that were sustained in the eruption. The bodies of 2 people were never found, and it's thought that they slipped into the sea. The country and the world, in many ways, wept with us that day. Now, the context that we now live in is, of course, very different from that 1,000 years earlier, when Muriwai placed her rāhui. The fabric of Māori society has been eroded over time as a result of colonisation, as a result of assimilation and systemic laws put in place as a result of land loss. We're well familiar with that history. We now live in a very mixed and diverse communities where people hold very different beliefs. We use TikTok. Some of us do, not me. But despite the great societal shifts that have occurred, the Māori response to this tragedy was very similar. A number of coastal iwi, including Ngāti Awa, Te Whakatohia, Ngai Tai, and Te Whānau Apanui, all did what Muriwai did. They placed rāhui along the coastline, as this map illustrates. It wasn't quite as big as the rāhui that Muriwai placed. It didn't need to be, partly because what these coastal iwi know is that the currents from Whakaari tend to go east. And so what they did was place a rāhui from about Matata all the way again to Tihiro. This time the public rāhui was for a much shorter period of time. It was for about 2 weeks, although I do know a number of whānau and hapu that during that summer period didn't use the ocean or eat fish from the ocean, so for a longer period of time. But the effect was the same. I went down to the beach because I live in Whakatane most days for that 2-week period, and it was eerie in some ways because we are a coastal ocean-going community, but there was no one in the water. There were no boats in the water. There were no people in the water. There was no one gathering food during that period. For a brief sort of 2 weeks, we all collectively paused and didn't use the sea. Businesses rely on the sea in Whakatane. Right? This was December, not quite the middle of summer anymore because of climate change, but pretty hot still then, right? I found it remarkable that that was observed not just by those who necessarily believe in and subscribe to tikanga, but it was observed by the whole community, at least on that occasion. I've drawn on those examples because what I'm hoping it starts to do, or might start to do, is to help us think about the tapestry of law that operates in Aotearoa in a deeper, richer, and more complex way. One of the tendencies of many Māori is, of course, to identify tikanga as law LORE instead of LAW. I looked up the definition of LORE, which in the Oxford Dictionary refers to stories and traditions of a particular group of people. Of course, tikanga does have stories and traditions associated with it, but it is much deeper than that. Tikanga is a living, evolving, dynamic, pragmatic, responsive way that Māori not only view the world, but it's also what regulated and still regulates to a certain extent behaviour and relationships between people, as well as between people and the environment. I 100% appreciate why some have an allergic reaction to calling it law. Law is a non-Māori word that has significant cultural baggage associated with it. It's also been one of the primary instruments through which Māori have suffered significant harm over the last 180 years or so. Further, most of us, particularly those who have gone to law school, have it drilled into us that law just comes from two sources: courts and parliament. State law. That's what's deserving of that title of law. But I think it's important to understand that the state does not have a monopoly over or exclusively own the concept of law. There are different layers and ways of thinking about it. I used to teach the subject of jurisprudence at Auckland Law School for a number of years. Right? Jurisprudence is like the theory of law. It was compulsory up there and a subject that most students hated actually taking. And take it from me, there are literally thousands of books and libraries filled with people pontificating about this question of what is law. And it's easy to get tangled in what it is, what it isn't, and specific definitions about it. But to me, if you strip it down, law is a very human construct, and a way of ordering society and regulating behaviour. Although the idea has been used in different ways across time, cultures and contexts, if law is what governs society, tikanga was indisputably our version of it. It's the first law of Aotearoa, and it dictated the rules of how we engaged with each other and the world. Although the meeting of two worlds, cultures and laws, has of course impacted tikanga, and in many ways left it battered and bruised, it still survives. You see it on our marae. You see it in our homes. If you understand it, you see it etched into our landscape and in the layers of rights and interests that flow from our history of engaging with each other and with the environment. You see it in the example of the rāhui that I used, where each of those iwi had the mana to place a rāhui over their ocean territory. Permission was neither sought or required from the courts or from Parliament. It wasn't required 1,000 years ago. It wasn't required in 2019. Their source, authority and effect in both instances flowed from and was grounded in tikanga, a separate source of law in Aotearoa. If we think about law as being a mechanism through which behaviour is regulated, I want you to just think to yourselves about two questions. Think about the whakaari rāhui that was placed. Would you, or did you, if you were there, abide by it? If so, the harder question, why? Just pause and think about that for a moment. There's likely to be lots of different answers in this room, both as to whether you would follow it or not, and why you may have done so. But I'm going to throw out a couple of suggestions as to the why, and put your hand up if you feel that it resonates with you. So one reason might be you agreed with the reason for it, i.e., rāhui serves a function and a purpose, respecting those who passed on that island, as well as a very pragmatic reason of not wanting to be exposed to the dead. There were people still in the water at that stage. So put your hand up if that would have been one of the reasons why you might have followed the rāhui. Another reason, you may have been swayed by potential punishment or consequence. Whether that be the spiritual consequences of breaching a tapu or wanting to avoid the scary Māoris that might come chase you on the beach. Put your hand up if that may have been one of the reasons that you would have followed the rāhui. Some, less. You might be, or another reason, possible reason, is you may have followed it because it's what is tika, or the right thing to do. You're a rule follower. Someone says don't do it, you don't do it. Put your hand up if you fell into that category. Finally, you may have respected the authority of the iwi to place it. Put your hand up if you fall into that category. Now, I want to pivot away from that example for a second to a completely different one that you'll all be familiar with. You wake up, you get out of your bed, you have a shower, you jump in your car, and you arrive at a stop sign. Why do you stop at a stop sign? Again, might be many reasons for that. One, put your hand up if it's because the very pragmatic reason of not wanting to crash into somebody else. Kia ora. It makes sense, right? There's an ordering of society that needs to occur. And the pragmatic rule or the pragmatic reason behind it makes sense in that context. Put your hand up if you're swayed by the potential punishment, i.e. the $150 or whatever it is if you breach. Or the telling off from the cops who might be waiting around the corner. Less people. Put your hand up if you stop because it's law. That's the rule and you follow the rules. And finally, you may respect the democratic lawmaking institution that we voted in Parliament to make laws for the good of people. Put your hand up if you fall into that category. Way less. Real pragmatic people in here, eh? I guess the point of drawing on those two different examples, one grounded in tikanga, one grounded in state law, is to start to get you thinking about the nature of law. Both of those examples, the stopping at the stop sign and the rahui example, both are intended to regulate behaviour. Both claim a form of authority, whether you follow it or not. And both have mechanisms for enforcement, albeit different types of mechanisms grounded in each. I think it's now relatively uncontroversial to call tikanga a system and form of law. In fact, in a Supreme Court decision that I'll come to talk about soon, one of the judges in that decision says tikanga will continue to be applied by Māori and will continue to develop independent of its place as part of the common law or legislation and policy. In this sense, tikanga is a separate or third source of law. The more challenging question, though, is no matter what you call it, what does it mean? What does it mean for us? What does it mean for Māori? What does it mean for the general populace? Who has to follow it? What is its intersection with state law? If there is a rahui over an area like the one that was placed up in Auckland because of the Cody dieback disease, do we have to follow it? Right. Challenging questions to work through as a society. My observation is that there's two things happening in Aotearoa in this space at the moment. One of them is that for the past 40 years, there has been a process of reclamation, rejuvenation, and a strengthening of Māori society. It had been eroded for a long period of time. But in the 1980s, for those of you who were alive then, right, it was a time of protest. It was a time of activism. Around the world, not just in Aotearoa, but there's those beautiful images of Whina Kupa walking her mokopuna on the Māori Land March down to Parliament. That was a result of Māori being at breaking extinction point. It's a result of a generation who never learnt how to speak te reo, but they went to uni, got an education, and decided, hey, we don't want to miss out on that. Right, so that's been one of the things that's been happening, I think, over the last 40 years. And I think one of the developments or one of the things to think about conceptually is if you're thinking about tikanga as its separate source of law, one of the developments is that Māori are reclaiming that. It never went away, but there was a huge impact on it for many years that in many ways impacted our ability to exercise it. So that's one of the developments that's occurring in society. Alongside that is you start to get tikanga speaking more to state law. It always has. We have cases from before 1840 that talk about the recognition of customary law in the state law, in our courts, in the common law. But there was a long period of time where that was not recognised despite those precedents that we have. So what I want to talk about for the balance of my lecture, and I have no idea what the time is and I have no idea how quickly I'm going, is the second development. How tikanga is increasingly being drawn upon as part of the state legal system, or increasingly part of our matrix of laws that's applied in that way. There is a lot to be said about that, and we could be here and have a whole course on that subject. Right? There's a lot happening in that space at the moment. So I thought the best way to look at the issue would be to view it through the lens of a particular case that I was involved in. And partly I think it's because it is illustrative and can help show us the trajectory of where I think our legal system is going. Tikanga came before the Supreme Court in their most unlikely of cases a couple of years ago. The Peter Ellis case. Most unlikely because there were no Māori involved in this case. The facts are likely familiar to you, but I'll traverse them very briefly. Mr. Ellis was convicted of child sex offending in 1993. He was an early child care teacher down at a creche in Christchurch. The case was, and still is, a very well-known one. And I understand had a major impact on males in the teaching profession in general. In 1999, the Court of Appeal upheld the verdict, as did a subsequent ministerial inquiry. 20 years later, in 2019, the Supreme Court granted him leave to appeal his original conviction. So they said they would hear his case, i.e. that there was a possible miscarriage of justice that may have occurred. The primary grounds upon which it was being appealed was that the evidence that they had relied upon, i.e. the child interviews, those had been conducted in an unsafe way that effectively implanted various memories into the kids. So he was granted leave in 2019. He then died after a very short 4-month battle with cancer. The issue that then confronted the Supreme Court was, what do we do now? Do we continue to hear the case? In that particular case, Mr. Ellis had instructed his lawyer that he wanted the case to continue. So there was clear instructions from the client. He also wasn't needed in the case, i.e. it was a matter of law that was being appealed. He didn't need to give further evidence or anything like that, for example. So some of those pragmatic kind of things that lawyers think about in terms of making sure you've got instruction, etc., were less relevant in this particular case. Usually what happens when someone dies is komutu. That's it. Right? The case dies with the person. The end. The few exceptions in New Zealand law when that hasn't been the case has tended to be when like money issues are involved. So for example, when like a whānau needs to carry on the case to try and get money from someone on behalf of the estate. So our traditional English common law view of the world is that when a person dies, their interests end with them. Right? So it's a very individualistic particular to the person, way of thinking about legal proceedings. The Supreme Court, and so I wasn't involved in the case at this point. The Supreme Court initially heard arguments from, that second picture is Mr. Rob Harrison, who was lawyer for Mr. Ellis, in the original hearing when he was convicted, and then also came back sort of 20 years later to be involved in the case. So heard arguments from Mr. Harrison, as well as the Solicitor General, Una Yagos. So they got up, armed with, as you do, all your international precedents from like Canada and Australia, trying to argue the case. When they got there, one of the oral questions that was posed to them by Justice Glazebrook, one of the Wahine Supreme Court judges, was, well, what's the relevance of tikanga to this case? They were not prepared to answer that question. So what then happened was that court adjourned and they were given an opportunity to do so. And they were asked 3 questions. Is tikanga relevant to this case? If so, what is the tikanga that applies? And how does it apply to this particular factual scenario? The question they were dealing with wasn't whether he was guilty. The question was, should the case continue to be heard given he has died? Now, at that point, these Pākehā lawyers freaked out because they didn't know how to answer that question or even where to start. I actually only came on board because I saw it, a stuff.co.nz article, seeing that they'd been asked this question, was like, oh, and I'd sort of written some articles and stuff and was very interested in this topic. Saw that they'd asked this lawyer, Googled him, Pākehā lawyer from Blenheim. I was like, you might need some help. So I flicked him an email, gave him a call and said, hey, do you want some help? I'll just do it for free in the background, help you write your submissions. I just don't want you to F this up. Because it's the first time the Supreme Court had really, apart from in a 2012 case of the body snatching case, for those who are familiar with takamori, first time they'd really been asked and were directly confronting the question of where does tikanga fit in our laws. Right? I was like, we can't get this wrong. So anyway, I came onto the legal team alongside with another Māori lawyer, Kingi Snauga. What then happened was the Crown got a number of their Māori lawyers who were working for them to come on and give them advice. And Te Hungaroia Māori, the Māori Law Society, also waded in at this point as well. What you usually do when you're asked a question like that, right, we're used to that very adversarial environment. So you'll go back, you'll arm up with your team of experts who both say different things, and then you'll come to court and scrap it out. And whoever has the greatest sort of credentials or whoever sort of sounds the smartest and the brightest and whoever has the most mana, you know, the court will be more convinced by them. So that was the usual approach to what you would do in that scenario. What all of the people decided to do, and credit to the Crown, because this is the first time they'd done this, we all decided, what do you do when you're asked a tikanga question? You wānanga. Right? So we brought together about 10 tikanga experts down in Wellington. So you start, that drew on the likes of Sir Hirini Mokomead, who wrote the book on tikanga Māori, Sir Pau Temara, Professor Rawenia Higgins, a bunch of these incredible tikanga experts, to ask them. So we spent 2 days having a wānanga around how tikanga might apply to the particular fact scenario of the Ellis case. Their answer was actually really simple. We didn't need 2 days. In Te Ao Māori, when a hara or a wrong is done, it negatively impacts people and mana, both of the individual and the collective. Now, in the Ellis case, it's unclear at that stage where the hara sits. Right? He had been convicted, But then there was also the question that the Supreme Court opened the door up to whether he was possibly innocent. Or if not innocent, whether his conviction shouldn't stand. Right, so unclear where the hara sits. But in Te Ao Māori, when there's been a wrong, there needs to be a rebalancing of that wrong. And that can be an intergenerational process. As we all know, we still scrap about things that happen like many, many centuries ago. We've got a bugbear with Te Arawa about how they did la. You know, so in Te Ao Māori, that process of trying to get to a state of ea, spelled EA, a state of balance, is one that transcends death. So that was effectively what the tikanga experts told us. So we then had to go back into court with that information to pitch our different arguments about, knowing that's what it says, what should the court now do? So I was fortunate at that point to make the oral submissions for Mr. Ellis in the Supreme Court. What I did to try and get them to picture one of the tasks that they were charged with doing is to draw on a whakatauki or kōrero that was said by Potatau Te Wherowherero, the first Māori king, where he said this at his koroneihana, coronation, in 1858. He said, "Ko tahi te kōhao o te ngira, e kuhuna ai te miro mā, te miro pango, te miro whero. There is but one eye of the needle through which the white, the black, and the red threads must pass." He said that in response to the words of Te Hiuhiu, a chief of Ngāti Tūwharetoa, who said to him, "Potatau," I roto i te reo Māori, I'll just say the English version, "Potatau, this day I create you king of the Māori people. You and Queen Victoria shall be bound together as one. The religion of Christ shall be the mantle of your protection. The law shall be the whāriki for your feet, forever and ever onward." Drawing on that metaphor, I asked the court to conceptualise themselves as kairaranga or weavers. Not the only one in Aotearoa, but one of the weavers that add to the fabric of law and weave it in our legal system. What I invited them to do is, when they do that, to not only draw on the thread of law that is derived and comes from England, but also to pick up the thread of law grounded here, grounded in tikanga, and also weave it into our laws. What I did, hopefully, is paint a framework for how the intersection of tikanga and the law currently works. Right. First, and this is not up there, right, is the way that I initially talked about. It exists separately. Right? It's law in and of its own right. And like the rāhui, doesn't need the state legal system for it to have any form of validity or effect. But there are a bunch of other ways it is also relevant in the state legal system. One is when legislation directly recognises it. So there are a number of ways in which Parliament has decided to weave tikanga into our laws. So, for example, the Resource Management Act talks about kaitiakitanga. For those who work with the new Oranga Tamariki Act, the old Child, Youth and Protection Act, it weaves in mana tamaiti, whanaungatanga, manaakitanga, as concepts that form part of the directly enforceable law of Aotearoa. And as lawyers, we need to grapple with those. And when you're grappling with them, you're not only referring to those words, you're referring to the whole interconnected system and matrix and system of law from which those words come from. So that's way one. Way two is thinking about tikanga in the common law as a source of rights and interests that can be enforceable in court. Since, as I said before 1840, there's a number of cases in the common law that said that when a new legal system is implanted somewhere, it will recognise the local circumstances and laws of the land. So part of the arguments that are being woven in is that in the legislative cracks, judges can fill that in with the common law. So these sorts of things are, for example, if you think about, although it's now being replaced by a legislative scheme, the rights and interests that are claimed in the taku tai moana, right? Proprietary type rights. Rights that are derived from existing there for a period of time and exercising your customary rights and interests. There is an extent to which you can draw on those and have them enforced through the courts. The extent of how far, we're still testing out. But that's a stream of law that's recognisable. Tikanga is also relevant through Te Tiriti o Waitangi, which is also pepper-potted through legislation and has a legal impact as part of the interpretive tools that we use in our law. Where you have Te Tiriti, you have tikanga associated with it because it protects rangatiratanga. Part of rangatiratanga is your right to exercise your laws. Right, so it comes in through that route as well. The final way, and this was the way that was relevant in the Alice case, was that tikanga can be relevant to informing the development of the common law in general. So in this particular case, we weren't there saying Mr. Ellis, as a Pākehā, can draw on tikanga because he has rights and interests in tikanga. That was not the argument we were making. The argument we were making was that the laws of Aotearoa, the common law of New Zealand, when we are developing it for our society as a whole, can draw on ideas of tikanga when we're developing it. So that's effectively what we were saying here. Despite our laws generally saying the interests die with the person, tikanga can provide a framework and a different way of thinking about it that would enrich and enhance our laws and that may be more reflective of an appropriate way of thinking about that in Aotearoa, New Zealand. So that was the argument we made anyway. We then had to wait like 2 years to get a decision, but anyway, we got it in the end. The outcome of the Supreme Court decision, which we knew fairly quickly, was that they were going to grant it. It was able to continue. We didn't know why. They said, we'll release that when we release the substantive judgment. That's why it took so long. So they granted continuance. They then, and it was last year now, they then released the substantive decision as to why. And there were some really powerful statements, and I would commend that you read the case if you're interested in this particular topic, because they traverse the issue, I think, quite sensitively. Now, for those who aren't lawyers, the Supreme Court is made up of 5 people, and they don't always agree, so you tend to have multiple different judgments. And then you have to figure out what the majority says. So in this case, they wrote 4 different judgments. And so they all sort of said slightly different things, but there were some things on which they all agreed, or at least the majority agreed. So 5 out of 5 said tikanga has been and will continue to be recognised in the development of the common law of Aotearoa in cases where it's relevant. One of them expanded on what she thought this meant, Justice Glazebrook, and she said what this means in practice will need to be worked out on a case-by-case basis. It might be controlling. It might be a relevant consideration. It might have an influence. It might provide a new vocabulary of framework for thinking about the issue. 3 out of 5 said tikanga was the first law of Aotearoa New Zealand, and it continues to shape and regulate the lives of Māori. And 3 out of 5 also said that care must be taken not to impair the operation of tikanga as a system of law and custom in its own right. So what the judges were doing were trying to carefully navigate what I described sort of at the start, the system of law, what it means, how it operates separately, and how are we going to draw on it in the state legal system framework. So where does that leave us? I think it's a very exciting time to be involved in the law because we are figuring that out. On a very slow, case-by-case basis. It's open to argue not only that tikanga is a tool for Māori to claim particular rights and interests, but we're also heading to a place where tikanga can have an impact in a broader sense and starts to impact how the law develops in general. One of the cases that I'm currently involved in is quite interesting. It's currently before the Supreme Court, but it was a case taken by Mike Smith, one of the Ngāpuhi rangatira up there, against 7 of the largest climate change emitters in Aotearoa. He's claiming that they owe a duty and tort to him. Now, there's a whole bunch of doctrinal implications, and it was struck out in the courts below. We're waiting on the Supreme Court decision. But one of the arguments made was that tikanga arguments and ideas of treating and acting in kaitiakitanga with the natural world can help enrich the way we think about responsibilities to others and the environment. Will tikanga always be relevant to a case? No. Right? It won't always be relevant to the case that you're working with for those lawyers in the room. It's something you need to navigate carefully with your clients, whether it's appropriate to make that argument. Tikanga may not be supportive of your argument either. Right? So it won't always be relevant. But we're now at a space where it's possible to argue its relevance. And the tricky question more is grappling with how. I think, again, there's significant opportunity for us to develop a law that's truly unique and endemic to Aotearoa New Zealand. That does not come with no risk, though. Right? This process that we're engaged in, this nation-building process that we're engaged in. Based on the historical experience of Māori, courts have tended to treat tikanga and Māori poorly. There is a risk of, when you're handing something over to a judge, that they misinterpret, that they misappropriate, that they misapply that framework of thinking. So I know many Māori that are concerned about what that means, because you start to let some of it go to someone else, right? And there are risks associated with that. Part of, I think, what we're grappling with at the moment are how we limit those types of risks and how we responsibly and carefully traverse that intersection in a way that upholds the integrity of not only tikanga, but that then flows on to the upholding of the integrity of the New Zealand legal system in general. So, for example, the wānanga process that I talked about in the Alice case, right, that was one way in which it was those experts who told us how tikanga applied. Right, so deference to those people who are knowledgeable drawing on those people in responsible ways. The education of all of the legal actors is something that's also occurring. Professor Roy talked about the movement in law schools. There's also judges and lawyers that are now getting additional training in tikanga. This is not so that they become Professor Po Temara. Right? This is so that these people and us as legal actors develop an awareness more of the limits of our own knowledge. So that we know what we don't know more than anything else, and know when and how to seek help when we're traversing this kind of boundary in a responsible way. I also think the best way of protecting tikanga in all spaces is the work that's being done in the revitalisation space. If our sphere of law is strong, the drawing of tikanga into that state law sphere is not a threat, but something that is complementary. So I have no idea what the time is. It's like casinos, deliberately no clocks in here. But just by way of concluding thoughts, thank you for your time. Thank you for being a patient audience. I think we're at an important point in the history of Aotearoa, a period of nation building where tikanga Māori and mātauranga Māori are being drawn upon across all sorts of areas, not only in the law, in education, in health, in all sorts of spaces, in a way that I hope is beneficial. I think it's both exciting and tricky, and we've all got careful weaving to be done. Kia ora koutou katoa.
Kia ora tātou. My name's James McGillivray. I'm a partner at Tompkins Wake, and I'm going to be bringing this microphone round to anyone who wants to ask a question in a moment, so I'll get you to put your hands up in a second, but I'll kick us off. Natalie, that risk of colonialisation I think is a very real thing, because you kick something like this over to people with my training and we're going to want someone to put in a book, basically. Give me a book. Give me a book on tikanga so I can read about it and apply it like law. And it makes me think of the example of equity in the English legal system, which starts off as this very, very flexible set of ideas that sits alongside a legal system. And then that gets drawn into the legal system and lawyers drag it into legal processes and apply legal thinking to it. And what does it end up? It ends up looking like law. Is the key to stopping that from happening to change the processes by which we determine legal issues?
Kia ora. I think that's a really good question, because one of the tendencies of the state legal system is to codify, right, and have a bunch of precedents from which sort of then is locked in. I think process is important, but there's also an understanding that I think everyone needs about the way that tikanga operates to help avoid that. Right? So if you understand that tikanga is something that is context specific, it's not an idea that we're unfamiliar with. If you have an idea that tikanga, if you understand it as a system of law that is derived from the collective communities from which it derives, if you understand that, you start to know that to get an answer of how tikanga applies, you do need to start going to those experts to ask how it applies. Right? The Alice case may have turned out very different in a different factual scenario from a tikanga perspective. Right? If that issue had been lying dormant for 20 years, say, and there had been a state of air reached from that process, the tikanga experts may have said, no, you shouldn't go forward. But in this case, the door had been opened, so they said, well, that's kind of disrupted it. There's a question at play that needs to be answered, right? So I guess part of it is an education thing. And I also think there is a process thing that you've hit the nail on the head on. We're increasingly asking pukenga or experts to sit alongside judges to help guide them as they're engaging more in this space.
And it seems to me if it's going to be respected, it's going to be a less adversarial process.
Yes. Yeah, and I think there's the adversarial process, and there's a few things to be said about that, I think, as well. I think there is the rigour and the robustness of the adversarial process that we traditionally have really liked. But there is a beauty in the wānanga process, right? That wānanga process of bringing people together to talk about it, to work it out as a collective. And so I think as lawyers or people engaged in the law, it's about facilitating those types of processes to help us answer some of the questions that I think we need to answer over the coming decades.
Natalie, you talked about enforcement earlier. If Tikanga's not going to rely on the state to sort of weave it in and enforce it and maybe monopolise it, what other enforcement avenues are there besides being chased down a beach?
Well, the enforcement mechanisms we traditionally used are no longer legal. Instead of enforcement, I think that where we're at is a place where we need to think about it more in the sort of positive way. So where I see tikanga as having the most value at the moment is helping us resolve our own internal disputes. You know, Māori for a long time, and it's strategic, and I understand why we do it, we go to the court to do that, right? I think part of the strengthening of our own institutions is hopefully we won't need to do that. We can start to have wānanga, use mediation, go to matatini pōwhiris. Right? So I guess it's not about tikanga necessarily being used as a whip for everybody else. I think there's a journey that we're all on. I thought it was illustrative that I think most people in here followed the whakaari rāhui, or would have, right? For various reasons, not because you necessarily think it's law, but I think as we're sort of increasingly weaving it into our collective consciousness, what it is and why we're doing it, right? More people will start to respect it.
Kia ora, Natalie, mō tēnā. Yeah, thank you for that. I'm interested around Te Tiriti o Waitangi treaty question and how this is impacting or could potentially impact our way forward in Article 1, Article 2, ka wanatanga, tino rangatiratanga. Up till now, we're agitating for them to be hermetically sealed, that you have a ka wanatanga process, you have a tino rangatiratanga process, and of course mana motuhaki sits within that space of tino rangatiratanga. Here we are having a merging, in my view, of something out of the the taonga of tino rangatiratanga that's fitting within kawanatanga. I understand it because in your last statement you talked about it's a process that would be very helpful in Te Ao Māori for processing some of the raruraru or whatever comes up. But in the Peter Ellis case, for example, which is particularly a Pākehā thing, we're having a merging together of kawanatanga and tino rangatiratanga. And I wonder if you see, there's some beauty in that I can immediately see, but I can also see perhaps some of the dangers where people would say, oh, you've got what you need now, you have it within the kawanatanga process, so you don't need that other process. Does that question make sense?
Yeah, it does. The way that I see it is I don't see the kind of recognition of rangatiratanga as being mutually exclusive to what is also happening in the general state legal system. So that's why I sort of used that example of the rāhui at the beginning, because that's applying in that rangatiratanga space. That's applying without necessarily having to go to the courts or having to go to Parliament for it to have any form of legitimacy. It had legitimacy in and of its own right. That's the exercise of rangatiratanga, right? We saw it again with some of the COVID responses, where Te Whānau Apanui shut down their haurohe out of a precaution because they were scared that their whole coast was going to be wiped out, right? So you see, I think, that rangatiratanga space and some of the revitalisation stuff that's going on there, strengthening our own institutions. But I don't see the drawing of Māori whakaaro into the state legal sphere as necessarily compromising that. Different people have different opinions on that question, though. But that's the way I see it. And the space that I'm in as a lawyer is playing in the state legal space, so trying to create change in that arena. But I don't see that the way I live at night, well, able to sleep at night, is I don't see it as compromising that different kaupapa.